Hi, this is Attorney Kip Malek from Malek. I'm here with Attorney Greg Pace, and today we're going to be doing something a little bit different. We're going to talk about a fact pattern. I'm going to take a position that this claim shouldn't be allowed, and Attorney Greg is going to take a position that this fact pattern should be allowed. And the fact pattern where this came from is it's kind of anecdotal. Essentially, at our office, we have water coolers, and there's jugs of water that go in the water coolers. And so, in our office, we have the water coolers in the basement of one of the buildings. And so, to get the water coolers, you have to carry the jugs from the basement to the different floors in this building or the other building. And so, my thing is I don't want people getting injured doing that. So I tell people, don't carry the jugs of water up, anywhere. Let me know if the water's out. I will move the jugs of water. And so in this fact pattern, the situation is we have an employee that's moving a jug of water from the basement to the second floor. I've told the employee, hey, buddy, don't move the jug of water. I'll do it. The employee goes ahead and does that anyways, and when he moves it from the basement to the second floor, he ends up suffering a lower back injury, files a workers' comp claim, and then there's an order that comes out, and then we have a hearing. So we're kind of at the hearing level. And by the way, the employee that had moved the jug of water, his official job title or duties is a paralegal. So that's a sedentary type of job. You wouldn't be expected to be schlepping things up and down steps. You wouldn't be expected to be really doing any kind of manual labor. The expectation is you're picking up phone calls, you're typing the computer, you're picking up printouts from the printer. It's, again, sedentary type job. So that's kind of what we have going on here. And then so I'm going to go ahead. So if this was a workers' comp hearing, the hearing officer would say, okay, injured worker, this is your appeal. Go ahead and make your arguments. And so we'll start out with Attorney Greg.
Yeah, and I would disagree from the beginning that this is the sort of thing that, while not one of the job duties, it is reasonable that they might do this as part of their job. Because the legal standard for an allowable claim is that the action that was done that caused the injury was arising out of the job that you are doing, or is to the benefit of the business at hand. And I think what Kip is worried about is that the job is not moving water bottles, but where I'm viewing it is that this is just part of how an office operates. There's phrases about water coolers, water cooler talk, sitting around the water cooler, going to the water cooler, because everybody knows this is part of an office. So a paralegal is an office worker, and this is just part of how an office is maintained, is that there is a water cooler, and at some point in time, someone has to replace that water cooler jug. So I would argue in the hearing that the paralegal was doing their job, taking calls, helping clients. They needed water. The water was empty, so they took out the empty jug that is 1 pound, and they picked it up with a 30-pound, and they tried to replace it. They were doing their job. They're allowed to get water. Drinking water through the day is a normal part of their practice of working, and they got hurt doing that. The fact that they were told not to do it is a complicating factor, but that doesn't mean that they were not doing something that was helping in part of the business. And that would be the crux of my argument there. Most likely there'd be no contrary medical or no indication that this didn't happen. It would just be whether you were moving the water bottle itself was enough to qualify as a work injury, and I would say that it definitely is in the hearing.
Yeah, and I guess my position on this is, so when there's a workers' comp injury, there's two things that are part of that. Fundamentally, a workers' comp injury, it must be there's two things. It must be in the course of, and these are like magical legal terms, and they kind of mean the same thing, but they're I guess they're not. But they must be in the course of and the rising out of. So the in course of, there's this prong concerns the time, place, and circumstances surrounding an injury. And then the rising out of prong concerns. I have a mnemonic thing. I say PCB, proximity control benefit. So it's proximity of where the injury occurs to the workplace, the control of the employer has over the area where the injury occurs, and then the benefit to the employer of the injured worker being there. So, to Greg's point, if we're going under the arising out of, if we're analyzing that proximity, it happened at work, second floor of the building, control over that area. I mean, you can't argue that I as the employer don't have control over the area. It's our office. It's it's in our business, and then a benefit to the employer. I mean, the argument that you can make is, well, it benefits the employer to have people that are, I guess, properly hydrated, so, and like drinking water, making coffee, and all these things, as opposed to faucet water. Using faucet water, but that's kind of the analysis. And so within that analysis, they have other kind of things that are kind of in part of that, and it's like they say, is it logically related to the employer's business? Is it consistent with a contract for hire? Is it a personal errand that the injured worker is going on? So if I was arguing this, and again, I represent injured workers, I would never be on the other side, but if I was arguing this, and honestly, I kind of feel that for some reason, and of course I'm the employer here, and I am an employer, but it's hard for me to, because I'm like, I told you, like, Greg, I told you don't move the water bottle. And like, Greg, you're or whoever, you're an attorney. Like, where are you moving water bottles, buddy? And that's not logically consistent. And you could say, yeah, but that's like, we all drink water, and this is helping the business. And I'm like, yeah, I don't disagree with that, but it's hard for me to get over that. It's like, it has nothing to do with your work situation. The funny thing is when you look at this, when I look at these like in the industrial commission's full commission orders, like when you put these search terms in, like personal errand, not consistent with contract for hire, or even contract for hire, not logically related to the employer's businesses, those typically, this kind of discussion comes up when it's the going and coming rules implicated. You typically don't see this, where a situation where like an employee is told not to do X and they do X, and then they get injured, and it's denied. Now, to that point, we do often run into hearings where like you'll have the employer say, I told Joe, don't do this, don't get on the step stool and grab the widget from the top of the cabinet, and he went and grabbed the widget from the top of the cabinet. But that's negligence on the part of Joe. And if Joe's job is moving widgets and building machines from widgets, that would be logically related to his business. So it's not really the same as this situation. I don't know. What's your thoughts on that?
Yeah, I think this is a situation that is purely fact dependent and hearing officer dependent. The hearing officers act not only as the judge in these hearings, but as the jury. So they're the ones that weigh all of the evidence heard from all parties, whatever in the file, whatever is said in testimony in the hearing. And the hearing officer is going to know this law that we're referencing, but they're also going to just look at it holistically. And they would hear, they were explicitly told not to do this, but they're going to think through, I've worked in offices before, somebody replaces the water when the water needs to be refilled, and they're not going to be thinking about it from what is the specific legal standard. They're just going to say, this was clearly in the course of being an office worker, and that, I think, is about the extent of the thought process they're going to put in. Did that answer your question?
Yeah, I mean, it makes sense. I mean, so here's the thing. So doing this thought game.
Yeah, fortunately nobody actually got hurt at work doing this. This is purely a thought exercise.
And I'm just telling you, Greg, and you can tell everybody else, if they get injured at work, as long as they're not like, it's some insane thing where they're smoking crack out in the parking lot or whatever, and then Malek and Malek were pretty compassionate, so we would not be fighting against the claim. Now, as far as our TPA or something fighting it, I can't control those people, but we personally, we wouldn't be involved with fighting the claim. But let's change the fact pattern a little bit. This kind of illustrates some of the problems that I have, and it's about making the fact pattern a little bit more ridiculous. So let's imagine, we're on South High Street. The power grid is not the greatest here, particularly when you have like these 95 plus degrees days and then they have a thunderstorm. So we've had instances where the AC has gone on the fritz. So let's imagine Attorney Greg is you're not any kind of electrician.
No, not at all.
Okay, I don't want to assume anything.
No.
I mean, you could be like, oh, actually, I'm an engineer, but so Greg's like, oh, the AC's out, guys. I'm gonna go out there to whatever the AC unit. You got a screwdriver? Oh, here, I'll grab a screwdriver, and he goes out there and he's futzing around with the thing. He gets electrocuted. So, I mean, would you think that's a compensable
No, see,
claim?
that's where I agree. I think there's a scale here,
Yeah.
and that is on one extreme, where this is so clearly not part of the daily operations of a regular office.
Yeah.
A regular office worker does not fix air conditionings. They do not get on the roof and fix shingles. So that, I think, would go to where a hearing officer would say, sir, you were clearly not doing your job. This was not something that you should have been doing. And this is not arising out of your employment with Malek and Malek, and they're going to deny that claim. But I would ask you on the opposite end, though,
Yeah.
with your argument. What if you told somebody, "Hey, we've got a cleaning person. They're going to change out all the trash bags. You don't need to do that." Somebody has their trash bag fills up. Cleaning person's not coming in. They change their own trash bag, and they somehow hurt themselves doing that. That is such a minor thing. Would you say? Why would you do that? You don't expect that to be an injury, but you wouldn't tell someone, yeah, you really shouldn't have changed a trash bag that weighs an ounce.
Oh, you're saying the trash doesn't weigh that much in your little twist.
Yeah, this
Yeah.
is so tame that
Yeah.
you would never think an office worker shouldn't do this. Because you can imagine you get hurt moving a water jug, but you're not going to get hurt moving a trash bag, but we see people that do.
Yeah, here's the weird thing is like I don't know, for me I have less of a problem, and now it's kind of weird that the fact that the person got injured, like their trash is full, it's all it has is like a Coke can or something, and they throw it out, and it's, I mean, I'd be like, come on, man, like, man up, Greg. But I mean, hey, these things happen. I mean, my dad suffered like 10 years ago by just stumbling around in his garden. He got a serious back injury. So, but to that point, it's funny because I have less of a problem with the trash guy thing, and I don't know why. Because and I guess maybe it's because I'm like, hey guys, can you keep your area clean? And I have less. I guess my problem with the water jug thing is like, if the water jugs in this, and maybe I wasn't clear in this example, but if the water jugs are in building A and the second floor is on building B, and I tell you don't do this, that's kind of why I'm like, what are you doing? Why are you're schlepping all the way over here with the crazy water? But is it really that different from your situation? I suppose it isn't. I suppose it's within the realm of I don't know, the realm of possible. I find that more attenuated than the trash can, because the trash can is sitting in your office, it's building up, and it might be smelly, and it might be like, hey, yeah, and honestly, if you, and this is a directive to everybody who works here, if you guys throw out your trash cans, I mean, I'm not going to be mad, but you do have a good point, and the reality is, I mean, we do have injured workers, janitors and whatnot, who, what will happen is somebody will throw away it happens with liquid. They'll throw away containers of liquid, and they'll do this quick maneuver thinking it's not that heavy, and it's really heavy, and they'll tweak their back or their shoulder or something. But
Right.
yeah, it's weird. That one, I mean, but is it really that different from the water bottle thing? Because your job is not cleaning person. Your job is, answer the phone guy, type on the computer, and then or whatever. So
Yeah, I don't think it's that different other than the weight, and I just think the hearing officers are going to see this as they were clearly doing something to help the office despite being told not to.
yeah, no, I think you have a good point on that. It's funny that we haven't really I personally haven't run into a fact pattern like this that I can remember off the top of my head. I've run into a fact pattern where like the employer's alleging that the claimant was negligent. Fairly frequently. It's just a thing that people do, the employers do. So here's another twist. So you're arguing the claim's going to be allowed. okay, and perhaps it would. So the claim's allowed. So let's say they're schlepping the jug of water upstairs, and they tweak their back so much that they're asking for a temporary total, or they're going to get surgery. So let me ask you this. Let's say they asked for temporary total from the date of injury, ongoing. Do you think they would be entitled to temporary total disability comp?
So in this situation, has the person been fired for breaking a direct order not to move the water?
Let's say in this scenario, yes, they've been fired. But
Okay.
they went to the hospital. They called me and they said, "Hey, this is what happened." I'm like, "Dude, I told you many times, don't carry the water bottle."
So my instinct is, because again, we don't actually get this specific fact pattern very often, is a hearing officer, and this is based on new law from the Supreme Court from the last year or two. I think a hearing officer would allow the claim, but they would say you were fired for cause. So now the reason you're not working is not because of your injury, it's because you were fired. It's messy because the reason you were fired is the thing that caused the injury, but I think that they would apply AutoZone, which is the name of that Supreme Court case, and they would say you no longer qualify for compensation because you were fired for cause.
Okay. And so this is where we kind of flip positions. Yeah. So my read on this is, so there's this case called Gross 2, and I call it the Kentucky Fried Chicken case, and I don't know if it was Kentucky Fried Chicken, but essentially there was a kid working in a fast food joint, and I don't know if you've ever had experience working in a fast food joint or working with deep fryers. I've had that experience working with deep fryers, cleaning them, and he was instructed, don't do something with the deep fryer, and he did whatever he was told many times, don't do that, whatever he was doing, don't do that thing because it's dangerous. And so he kept on doing whatever he was doing, he kept on doing it, and eventually he ends up getting severely burned. And so, he gets severely burned, he requests temporary total disability compensation, and what the employer is arguing is that there's you've heard of the Louisiana Pacific case?
Yeah.
Yeah. So the Louisiana, there's 3 prongs or elements, and I'm not going to recite them off the top of my head, but I think the 3 elements is like there's a workplace rule. The employee should have known the workplace rule because it was communicated to capacity, and they violated. And the Louisiana Pacific basically says you've voluntarily abandoned the workplace, and therefore you're not entitled to comp. But in the Gross 2 case, what the Supreme Court said at that time was you can't both get injured and voluntarily abandon the workplace at the time that you got injured. And I think they're kind of throwing a bone, but I mean, it kind of makes sense. So it's basically saying just because you've violated the workplace rule, you're not voluntarily abandoning the workplace, and therefore you're entitled to temporary total compensation. That seems like a reasonable rule to me, and I hope that rule stays in place. Even though I find the AutoZone decision by the Supreme Court very problematic for a number of reasons that I've discussed in prior videos, but they have not touched that case, or at least that hasn't gone up through the courts like the fact pattern Gross 2. So based upon that, my argument would be that that individual schlepping the jugs up would, even if they're fired for doing that thing, they would be entitled to temporary total disability compensation. But I could also see what you're saying. I could see hearing officers being like, "Oh, AutoZone, deny comp," because I could see it. And the reality is, some hearing officers, I don't know, they feel like they got to protect the fund. I'm not really sure what's going on in their head.
Yeah, our concern is that they've been directed to apply AutoZone whenever possible.
Yeah.
And my worry, and we have not come into this specific situation, fortunately, is despite AutoZone technically not applying, the hearing officer is going to choose to apply it. Yeah. And I almost think this is a split the baby situation. They're going to think, I understand what the employer's saying. They told them not to do this, but they got hurt at work. I'm going to allow the claim, but they shouldn't have done it, so I'm going to deny the compensation. Where they can't split the baby the other way. They can't allow compensation and deny the claim, so this is their way of a little of this, a little bit of that.
Like a compromise.
Right.
Yeah.
Now, a hearing officer would tell you that they never do that. That's not a thing.
Yeah. The reality is there's things that go on, and I call them like soft factors. There's the in the face factors, like the case law and stuff.
Yeah.
But there's so many soft factors, and this is why and we're kind of going off the radar, off the range a little bit. But people are like, oh, AI is going to replace this and that, and it's like that's why there's so many of these soft factors that aren't related to the case law. It's like the hearing officer. What biases do they have? What do they like the attorney? Do they dislike this attorney? Do they like the look of this client? Like they like the way this client looks versus the way that this defense attorney might look. I mean, those are weird things, but there's weird and things that go behind the scenes, and they might be like, well, they don't want to punish the employers because their father was a small business employer, and they're bringing in, and I'm saying they, but he or she, but they're bringing in things that have nothing to do with workers' comp law,
Right.
and they're applying it. And that's the thing. They're humans, so you're getting a human decision. And the reality is, and this is the reality. This is the reality of Ohio right now. We are a very conservative state. The voters, perhaps you have decided to vote in that way. Well, this is when you vote for conservative political leaders, you get conservative laws, and that's how they've chosen to interpret this. It's more business centric, and maybe that's good, maybe that's bad. If you're at the wrong end of that, I suppose you'd argue it's bad. But you know what I mean. So
Yeah, and I think the hearing officers they tend to be they're most generous in allowing a claim. I think that they want to trust an injured worker on what happened, but as soon as the claim's allowed, now they're looking out for the employer. They don't want everybody in Ohio to be hurt at the same time and being paid at the same time and nobody's working. And I fear in this situation they would say, let them get their hospital bill paid for, but now they got to find a new job and the employer can move on.
yeah, I could see that happening. And again, it just depends which hearing officer you get and what's the day of the week. Is it the morning? Are they pissed off? Or
Right.
did you show up at the hearing, or did you show up at the hearing and you smelled like pot and they might not like pot?
Yeah.
And all these, again, soft factors that have nothing to do with the claim that influence the decisions.
And then there's other factors of have people moved the water before? Did they get fired for when they didn't get hurt? Did
Yeah.
you move the water before? When did the rule come about? Do people get in trouble for being late? Do people get in trouble for dress code? It depends on how lax the office is. Because if there's 1,000 rules and they're not enforced, then why would the employer be allowed to enforce this one? But if it's one of those companies where the employer enforces every rule, then this no moving water jugs rule might stand. That might be enough.
Yeah, yeah. Anyway, so that's this crazy fact pattern. But as I say at the end of all these things, like these things are incredibly complicated. I think what we're gonna end up doing in future videos is come up with fact patterns that we encounter, and I'll take a position, and Greg will take a counter position. I might not always take the position of defense. Greg, you actually worked for defense. He was a bad guy. No, he was a good guy. Greg was a good defense representative, but the point is, Greg might take that position. So we're going to explore these. So if there's any fact pattern, and you might try to put in your fact pattern that you're actually experiencing, whatever.
Yeah.
But we and the way we argue it doesn't necessarily mean the way that the thing's going to turn out. But bottom line is, at the end of all these videos, I always state workers' comp is incredibly nuanced, incredibly complicated. So I highly recommend you get a workers' comp attorney involved. And here's the thing, and I don't know if you agree with me or not, but you really got to find the attorney that you're going to stick with.
Yeah.
Right?
When I was on the employer side, the quickest way for claims to get denied were when they were unrepresented and they just weren't filing things correctly. It wasn't even based on the medical, it was just filed wrong, or they had an attorney that didn't know what they were doing. So, and the hearing officer can tell immediately the attorney doesn't know, and they're denying every request.
Yeah. So talk to as many attorneys as you need to find somebody that you trust and you agree with, and and you think it's going to work with you. No attorney can guarantee a result.
No.
We can't do that. If you find somebody that guarantees you either compensation or a specific result, don't go with that attorney because that's a bad attorney. The other thing is don't always go with the attorney that advertises the most, because some of the best attorneys, like one of the best intentional tort attorneys in the state of Ohio, at least Central Ohio, is this Mordarski.
Mm-hmm.
His website is like circa 1999.
Yeah.
But that guy will get this, and we're talking about workers' comp law, but that guy gets these multi-million-dollar, and he does zero advertising.
Right.
So, yeah. Anyways, I appreciate you guys sticking with us. I don't know if you had any other
No, that's
thoughts.
it.
All right, thanks.